do think we have a quorum of our working group. So since we have a quorum, we'll go ahead and get started. Mr. Attorney General or Justice Earls, would either of y'all like to say anything at the beginning to kick us off, or shall we jump right to business?
No, Leslie, I'll just thank you for chairing in Mayor Colvin's absence, and I understand he's going to join us in a little while, but thank you for leading us.
And just to advise, I have to jump off for about 45 minutes in the middle, but I'll try to stay on as long as I can.
All right, thank you. I think that where we left off last time, we had approved recommendations for asset forfeiture, and we had also approved recommendations for law enforcement recordings that were consistent with what we had looked at for civilian oversight boards. And the big question that was left for today first was to finish the recommendation regarding the release of law enforcement recordings due to a critical incident. And then also to consider whether body-worn cameras, whether we want to recommend that body-worn cameras should be mandated statewide. So what I will do is I'll go ahead and share my screen with you with last week's work product on it. And hopefully you should be seeing that. And these are the, in red is what was amended last week and what we talked about. So to briefly cover again, recommending amending the general statute regarding police recordings to specify that police recordings of critical incidents shall be released within 45 days publicly, and then that may be extended if necessary. And we hadn't finalized this language, if necessary to protect the integrity of an ongoing criminal investigation. And we had said if requested by the prosecuting entity. I will share briefly with you another example. Let's see. Of language for you to consider here. If I can get it pulled up. Let's see here. Here we go. Is that showing? Can y'all see the California General Code now, or have I switched screens?
Leslie, it's still on the recommendation.
Okay, thank you. Okay, now it should be on the California General Code.
Yep.
This is an example of what California does, and you'll notice that when talking about delaying the release of video pursuant to a critical incident, that the agency here, the burden is placed on the police agency to demonstrate that disclosure would substantially interfere with the investigation. And then 1 year from the date that the agency knew about the incident, they could continue to delay disclosure only if the agency demonstrates by clear and convincing evidence that disclosure would substantially interfere with the investigation. And then it goes on to talk about if the agency is delaying the release beyond the critical incident trigger, what they have to provide in terms of notice and notification to the entity that is requesting the release there. So that's something for us to think about and consider. I think in terms of the recommendation that we have, right now we have not specified, for example, what is the burden of proof that someone can use to not release pursuant to a critical incident. We have not said how long that release may be withheld, and we haven't specified, like California has done, whether or not there should be additional notifications, in putting the reasons in writing and that kind of thing. So the question for this group, I think, is number one, do you want to look at those things specifically? Or number two, do you want to make a recommendation that something like that be included, but leave that to the drafting of the specific statutory language to be done kind of in the implementation phase? So I guess that's where I'll start with the questions and the discussion. Sheriff, Chief, Representative Galliard, any thoughts on that?
Leslie, could you go back to share the screen again with the California language?
Yeah. Yes, sir. There you go.
So from a law enforcement perspective, what are the strengths and weaknesses of this statement? Does this hinder law enforcement's ability to do your job?
Well, I think what clear and convincing evidence would be, should that be spelled? Is that what you were alluding to, Leslie, that could potentially be spelled out in the statute?
So, I mean, clear and convincing evidence here is given its, I think, understood definition, the legal definition based on the case law. So it's going to be informed by the case law, the words clear and convincing, just like our understanding of beyond a reasonable doubt or probable cause would be. The question, I think, is, do we want to have a burden on the party who is withholding? If so, what is that burden? And clear and convincing is one example, as California has used. And the other question, I think, that is kind of a first question, is that the California statute puts the burden on the law enforcement agency. The way that we have drafted our recommendation is that it can be withheld if the prosecutorial agency so requests, but not the law enforcement agency. So that's then a question of, if I think it's a theoretical question for your group. If you believe that videos of critical incidents should be released within 45 days publicly, but that they can be withheld longer for a certain good reason, I'm using the term good just as a placeholder, who is the person that gets to say what that reason is? And how long can that go on? And so do we want it to be that the good reason is the prosecutor is working on a prosecution and release would jeopardize that prosecution? Or is the reason that the investigation is not completed and that might jeopardize the investigation and later prosecution? And so who is the requester? And then at what burden do they have to meet to withhold release if we've specified release within 45 days? Does that make sense, Chief?
Yeah, it does. It absolutely does. I'm okay with the language because I think we've sort of cleared up the time frame that video recordings have to be released, and this is for special situations if we have to hold it longer. So I'm okay with the language because it does give some flexibility for those, special cases and it doesn't have a specific time frame. Sometimes it's not the law enforcement agency that doesn't want it released. Sometimes it's the victim that doesn't want it released for whatever reason. And, or a victim's family member doesn't want it released for whatever reason. So, all of that could potentially fall into those clear and convincing reasons not to.
And so Chief, let me just make sure I'm getting what you're saying. Here, I've put back up our tentative recommendation. I've got highlighted in yellow, necessary to protect the integrity of an ongoing criminal investigation. We would change that language then, maybe extended if, let's see, the California language is clear and convincing evidence that disclosure would substantially interfere with the investigation. So we could change this to say, maybe extended if clear and convincing evidence exists period. So then we have release may be extended if clear and convincing evidence exists that release would compromise the integrity of an ongoing criminal investigation. Now, then the question is, who gets to request that extension? Is it the police agency or the prosecutor or both? I mean, I think that this is an opportunity for you all to discuss who you believe that the correct entity is. And then also, what's the end deadline, right? So California statute says it can't be extended more than a year without some really serious information about why. So do we want to have an end deadline? Do we want to specify what? I think we need to specify what entity does the requesting.
And it could be either or, you know, it could be that the police investigation is ongoing, or it could be that it's in the prosecutorial stages and the DA's office wants it, you know, so I don't know who should make the call, because it could be either or. And
I don't think that we need to specify. I think that there could be a number of cases where it could be handled through the district attorney's office or by the agency itself. And in some cases, it may be attorneys representing the victim.
mm-hmm.
So I don't see the need, because, you know, ultimately it'll have to go before a judicial official to determine whether that reasoning is sufficient or not, or justification for withholding it. So ultimately it goes to a judicial official, and I think that's where it should end up, regardless of who's making the argument.
So that's a good point, Sheriff. And to be clear, if we write this in, this is a brand new amendment. So we haven't yet said that it goes to a judicial official for that determination. But I think if we leave it saying that it may be extended if clear and convincing evidence exists, you know, we could take out if requested by and add if clear and convincing evidence is presented to a superior court judge, or if a judge so finds. We could add that to make it clear that the decider of clear and convincing is the judge. That would be different than California. California basically says, look, you just have to show the requesting person that I do have clear and convincing evidence. So it's kind of you put that out there and say, here's my clear and convincing evidence, which theoretically, I guess they could then challenge in the courts. But if we're saying the clear and convincing evidence is proven to a court, then that's a whole different setup kind of than California. And we can certainly do that.
I would agree with that, because sometimes if a police agency says that there are reasons for us not releasing this video, you know, the law enforcement entity saying it sometimes isn't convincing enough that, you know, there is a legitimate reason, and a judicial official could sort of be the deciding factor as opposed to the law enforcement agency. I hate to say for lack of trust sometimes that people might think that they're just saying that.
Leslie, can I make a drafting suggestion? This is Anita.
Please.
So could you say release may be extended by court order?
Perfect.
Yep.
Okay. And then the next question, I think if everyone's satisfied that that answers the who can request and what the burden is, I think the next question, or the only remaining question I think I see, is do you want to put a cap on it? How, you know, release can only be delayed for a year or so. Looking at California's statute again, after 1 year from the date the agency knew or reasonably should have known about the incident, the agency may continue to delay. And so they say after a year, that clear and convincing evidence has to be presented. This is more stringent than that. We're saying it's a 45-day release, but you can go to the court if clear and convincing evidence exists to keep it. So that, I guess, is another question. Our statute would be more lenient on release, I think, than California, given that, lenient, more, there would be more of an opportunity for an agency to withhold release in our statute at the moment, because it has to be released in 45 days unless someone goes to a judge to do otherwise. If y'all are satisfied with that, then the only other question I think is there an outside time frame where it must be released? Or because we have said that you have to go to a judge after 45 days, do we not feel like there has to be an outside time frame? California's basically says you've got a year to withhold release, but if you get to a year, you have to show clear and convincing evidence. We're making that showing of clear and convincing at the 45-day mark. So it's a presumption of release unless at 45 days, and California's presumption of release unless is at a year. Does that make sense?
Yeah, and I don't think we should put a time frame on it, because we're addressing that issue up front by going to a judicial official. And if the case is made beyond that, I don't think there should be a cap. I think what we're proposing is a much more defined way, and bringing a judicial official into the process within 45 days covers that.
Chief, Representative Galliard, what do you think?
I agree.
I don't think well in abstract, so I'm trying to put myself in a real life situation to make sure that I'm kind of covering, all the spaces with this.
So let me give you a hypo. So we have an officer involved shooting, and there's body worn camera on the officer. Under this statute, it would qualify as a critical incident because it fits within our definition that we wrote last time for critical incidents. So within 45 days, that body worn would have to be released publicly to the media and everyone, unless clear and convincing evidence existed that it would compromise the integrity of a criminal investigation. So at that point, either the police agency or the prosecutor would go to the judge and say, we can't release it just yet because we're still trying to figure out charging. We haven't finished our IA, and we might end up having to charge someone. And so we can't release it because it might compromise that ability to
Leslie, I think your internet is going out. You there?
She looks like she's stuck.
Yeah, I think so. So I guess while she's coming back, I guess my concern, or at least my question, has to do with once that clear and convincing evidence is presented and the decision is then made not to release the footage, where are we in 60 days, 90 days, 180 days? Does that generally come back from the judge saying, okay, you've got another 90 days to address this? Or based upon what Sheriff Ingram is saying, at that point, there's just no cap, and really law enforcement then has, and this is a question, law enforcement then has basically the option of just forever sitting on that footage. Because we put no cap on it, they can kind of move on to the next thing. I mean, is that a scenario where it's possible?
That's a legitimate question, Representative Galliard, because you don't want it to just be forgotten about. It's like who stops the clock on it? And, when is the clock? It actually be, the trust of the agency to say we're done. So now you can have it. And I see what you're saying. There may need to be just some other mechanism or some other language in place. I don't know if it means to put a time frame on it. What are your thoughts, Sheriff?
I think we could, if it's being held to preserve the integrity of a criminal investigation, which I think is what we're talking about here, most everything else would be released, then it could certainly be tied in some way to the adjudication of the case, completion of the case, one way or the other, if necessary at that point. We have to be mindful of how that could impact a case. And it may be in it may not be beneficial to law enforcement. It may be beneficial to the defendant as to how that information is withheld if the argument is made. Again, I see a few times when it would be, but I understand what Representative Galliard's point is too. We don't want it to be open-ended, so I certainly think we can look at language like that to ensure that at some point it's not forgotten and it will be released.
So I think Leslie, oh, sorry.
No, please, go ahead.
No, I was just going to say, I think Leslie is back. And so I don't know how much of what we're discussing you caught, Leslie, but I just expressed a concern that the way the language is written, it provides law enforcement or even the defendant an opportunity to present clear and convincing evidence. And then once I get over that initial hurdle, I could potentially be done with this and never have to worry about it resurfacing. And I was just trying to make sure that we had language such that there was some type of requirement that we get to the finish line on this release.
So for example, would a requirement to review that decision at earmark satisfy that concern? Meaning that within a year, an IA should be complete, a charging decision should be made. If we're not at a charging decision and an officer involved or a critical incident within a year, then I think that we likely have larger problems. So at that's an arbitrary deadline, but is there a time frame where you would suggest clear and convincing evidence, it gets withheld until, and then a review date is set to determine if it still exists at that point?
I was going to make another drafting suggestion to address this, which would be to leave it in the hands of the court, depending on the circumstances of the case.
Yep.
So instead of just release may be extended, if it said release may be extended for a specified period of time, and then the court would specify, at the end of the proceeding or within 6 months, but it would put the burden on the court to determine some period of extension that is not indefinite.
I like that.
Which is
I can
how
live with that.
our protective orders currently work. If we were to apply for a protective order for certain pieces of evidence in a criminal trial, it would work that way. The court would put a time limit on that. So that's.
I can live with that. That satisfies what my concern was.
Chief, Sheriff, does that satisfy you?
Yeah, I think it's satisfied, but I'm wondering, should there be, a specific time frame for when the case is finalized, when there's a disposition on the case, that the video footage should be released within a certain amount of days at the conclusion of a case? I mean, I don't know. I think it'll hold, and I agree with Justice Earls is saying here, but I'm wondering whether or not, when it's done, you have a week to release this video footage, and that there isn't any more internal lag for the lack of oversight, because at that point, who's going to pay attention and who's going to hold the agency accountable once it's all done? I'm just wondering whether or not we should put something in there to at least say when the case is completed, or if when there's a disposition, the video footage should be released within 5 days. I mean, I don't know. Or does what we have here satisfy that requirement to release it in a timely manner after the case is completed?
I think as drafted, any party could go back to the court and say, it's no longer necessary. A decision has been not to charge, and so it is no longer necessary to withhold this video. And so, court, would you reconsider that? I think that this gives that ability to do that by any party.
Okay.
If you want it to be more clear, I do see a scenario where we may want that order for non-release to continue if, for example, you're going to prosecute an officer. Because if you are, then you worry about jury pool taint and that kind of thing. But at the same time, you will have had an indictment probably making it clear that there is a prosecution that is going to happen. So the public will know that action is being taken because an indictment is a public document. The flip side of that, if it is closed with a recommendation not to prosecute or declined, then we could add another sentence that allows specifically or requires release within a certain amount of time of that declination. Or we could, this language also gives the ability for any party to go back to the court, I think, and request a change to the order.
Leslie, just for clarity for me, the way this is written, would it not be an automatic trigger that upon the completion of the criminal investigation, the information would, the footage would already just automatically be released? Or is there a scenario by which there's no requirement that footage has to be released?
The latter. I think that under this formulation, the time period specified in the court order governs. And so, as with any potential litigation, we can always go back to the court and ask for more time, or say that our time, we don't need any more time, and it's fine if the court order expires. But as drafted, it does not provide for an automatic release at the conclusion of any investigation. And there may be good reasons to withhold release if it is moving forward to a criminal prosecution, but there may not be good reasons to withhold release if it is not. And so the question, I think, is, do we add another sentence that says, upon declination to prosecute or something like that? You know, all of this will be fleshed out more fully, I think, by the legislative drafters, but we could just add another subsection that says, when a critical incident does not result in a criminal prosecution, these police recordings must be released within X days of that decision. That leaves the, if we do something like that, and the 10 is, I just threw 10 in there. But if we do something like that, it leaves the wordsmithing to the drafters of the statute. They are certainly going to be better at it than I am. But it makes clear that what we are recommending is that when we have a critical incident and it does not result in charging, that the recordings have to be released.
Released within 10 days.
Or yes, I say within 10 days, and you can change that to 5 or however, 7 business days or 5 business days or whatever you feel is appropriate.
Mm-hmm.
Can either the chief or the sheriff put me in the shoes of law enforcement for just a moment? And when there's a critical incident, I'm an officer, I was involved. Now there's been a decision not to have a prosecution, but the footage now has to be released. What is the, I guess, emotional, social impact on that officer at that point? Is he or she generally feeling vindicated, or are they generally feeling more victimized by the whole process? My whole personality is very neutral. I like to see both sides of an issue, and I'm just trying to understand the implications for this for law enforcement.
Yeah. I think they can have varying impacts, because as we discussed earlier in our conversation, sometimes video footage doesn't capture an entire scenario. And whatever is, whatever snapshot is sent to the media sometimes can incite or create, more animosity, even if an officer is not prosecuted in a situation, it does cause a lot of, emotion and stress, not just with the officer, but the officer's family as well, especially if the entire snapshot, and sometimes it has even required me to ask the media, please show all 3 videos so that people can see the entire picture of what occurred here, as opposed to that one piece that sort of incites, a negative response. But at the same time, it could have just the opposite. And sometimes, to your point, Representative, I'm thinking more of the victims or those other individuals that are in those videos, especially when it's one where a person has been seriously injured. I'm constantly thinking about, are we really going to take the family through that again? So, there are a lot of different angles to really look at it.
That's helpful. I appreciate that. And
Representative
Sure.
Gaffney, I just want to thank you for taking that in consideration, because so many times, especially in the recent past, that's not taken into account. Many of our officers are really broken down by being involved in a process like that. They're going through a lot of issues. Post-traumatic stress is a real concern. We have seen it drive some officers to the point of taking their own lives.
Yep.
And this could, just the viewing, just for simply viewing, concerns me, because there are so many situations that, as the chief mentioned, it's only a small, narrow snapshot of what actually occurs.
Yep.
And unfortunately, in our society today, that's all people are concerned with. They just want to see what supports their narrative. And I believe that this could potentially cause us to lose a lot of good officers in the long run, or cause them to second guess themselves to the point of making a decision that costs them their lives. So I thank you for at least taking that into consideration. It means a lot to the law enforcement community because it's a real concern.
Yeah, I agree. I absolutely agree.
So I think,
Go ahead.
so I'm sorry, go ahead,
No,
Representative
you go
Gallagher.
ahead, Leslie. Go ahead.
I was just going to say, I think that to address a couple of thoughts that the chief raised, if we look at C, D, and E, we have specified that these must be redacted to protect victims and privacy interests of non-involved individuals. We have specified notification 10 days prior, which if we leave 10 days for release, that dovetails with that time frame to notify them. So at least they will have that lead time knowing that it will be released. And then, of course, working with the victim advocacy groups, I think there may be things that we are not considering here. And so continuing to do that. We could do the same for, other law enforcement entities, or consider employee assistance program recommendations. I don't know if that is the same, but it is a critical incident is difficult for everyone. And so do we want to make any recommendations there? If we don't want to add anything additional to this recommendation, whether we're ready to vote on it. So I guess my question first would be further discussion. And hearing none, I guess I would take a motion. Unless there's further discussion.
I just can't, I'm not comfortable with supporting B in that process, so I would have to vote against it.
Chief,
So,
Representative Galliard.
Keisha, please.
I'm just wondering what are, I'm trying to again run through scenarios as it relates to these decisions, real life scenarios. And so without this language, Leslie, of B, what then begins to be the process following, say there, the critical incident does not result in prosecution. What then is the process to get that recording released if indeed there was a group of people or individuals that wanted it released? If we didn't specify in this and I wanted it released, what would be that process?
Sure. So the language in number 1 says shall be released publicly within 45 days. So that's a presumption of release of law enforcement recordings within 45 days. A then modifies that to allow that to be restricted. So then it would be a couple of things. If the court order expires as we have it drafted in A, at the specified time that the court gives for the extension after the 45 days expires, whether that's 6 months or a year or in a criminal prosecution or something like that, at the expiration of that, I think that the way this is drafted, it goes back to number 1 where it's a shall be released. So it may be that B is unnecessary the way that we have it drafted.
Yeah. That was kind of what I was thinking as I read it more. Really, it seems like just number 1 will take care of any release of police recordings without the language about whether it's prosecuted or not.
And the other thing about that is that, having A in there is if it needs to be withheld for an additional period of time, it gives the option to go back to the court for additional time period. If the court gives 6 months, you can certainly go back to the court and say, here is my clear and convincing that I need 6 more months, Judge. And I think that this leaves the ability to do that.
Before we make a motion on this, I do have a question that unfortunately I probably should know the answer to, but I don't. And so I want to understand who the public is in this. And so is the public anybody not in law enforcement? So let's say there was a critical incident involving a police officer and it was my family member. And as a result, we had an attorney that was looking at this and we wanted to get all the possible information we needed to know what to do. Would my attorney and my family be considered the public because we're not in law enforcement, or is the public considered anybody that's outside of the scope of the investigation?
I think that it's anyone not in possession of the recording. So law enforcement will be in possession of it and the public is everybody else.
Okay.
Other than, there are certain rules where law enforcement has to turn over to prosecutors, et cetera. So I think prosecutors are probably excluded from that as well.
Gotcha.
But I think it includes the public. Yes, sir.
How is the current law written with regards to the release? Can we review that one more time as compared to what we're talking about?
Definitely. Let me pull that up for you. I've got it right here. All right. So this is North Carolina General Statute 132-1.4A. And so it defines what the recordings are up top. Then it talks about disclosure general. I'm here in subsection C. Recordings in the custody of law enforcement agencies shall be disclosed only as provided. And then it says a person requesting disclosure must make written request to the head of the agency and the date and the time of the activity, et cetera. And then the head of the agency may only disclose. And that's an important set of words, may only disclose. It limits the head of the agency to only being able to disclose, first of all, to these set of people here, a person whose voice, image, basically someone who is represented in some way or their representative in the video. And they may only disclose it to those people. And then the law enforcement agency shall disclose only those portions that are relevant to the request. And then upon written receipt, the law enforcement agency head must either disclose that or notify the person who requested that they're deciding not to disclose it. And these are the factors to consider, 1 through 6 here. Whether they're one of the authorized people, if the recording contains information that's otherwise confidential or exempt, if disclosure would reveal information regarding a person's highly sensitive personal nature, harm the reputation or jeopardize safety, threats, that kind of thing. And so then if denied, then the person may go to the Superior Court, basically, and request from the court. And then the court conducts an in-camera review and looks at it to see if the law enforcement agency abused discretion in denying the request. And then the court may only order disclosure of the portions of the recording relevant to the request again. So it's an abuse of discretion standard upon the court review. That's the initial release by the law enforcement agency head. And then there's an expedited process. So you can basically go to the court and ask for a court order for that. And the judge has to look at certain factors.
But as it's written, Leslie, currently, theoretically, could someone go to the court and petition the same day for a release? And if the court grants it, it would be released versus disclosed?
I think that's right. Notwithstanding let me just read it again, Sheriff. It's been a minute since I've read this portion, but I believe that is correct. Shall be set down for hearing as soon as practicable, and then shall be accorded priority by the court. So theoretically, it could happen same day. And sometimes it does when it's the media requesting. You know, I have had to go to court same day and try to argue about release of records with the media. So sometimes that could be possible.
Well, I'm just trying to understand that currently, the way it's written, you potentially can get it disclosed quicker than what we're suggesting.
Yeah, yep, you can.
Having someone petition the courts. And again, we're going to make that argument, but theoretically, the current statute provides for that and provides a mechanism for it. And it places it in the court's hands with regards to the decision. So,
But to that point, though, would this current language, wouldn't the opposite also work in this current language? If the court says, you know, we can't hear this for 70 days because that's the schedule, would it not potentially push this out? I mean, am I missing that?
You're right. Even though it says the language is for hearing as soon as practicable and shall be accorded priority by the court. You know, we're in COVID, of course, so, you know, that's, you know, what is practicable. I think that there are questions there.
could we not just look at suggesting a clarification in that area right there itself and put it to where it's given top priority on the calendar? I mean, it looks to me we have a really good statute in place currently with just a couple of tweaks, and to ensure that the court can be petitioned immediately and theoretically heard as soon as possible. I mean, if they petition on a Friday afternoon, you know, naturally it would probably be a Monday, but I don't know. It seems to me that we're almost complicating it even more versus what we already have in statute when we could just recommend a couple of tweaks as it's currently written.
I think the difference, Sheriff Ingram, is that, and I see Justice Earls has turned on, so she may also want to address this. I think the difference is that we would be stating a presumption of release with a critical incident trigger. Right now, the presumption is one of not release. The presumption in North Carolina is that these don't get released. But by enacting this recommendation, we are saying because of transparency, because of accountability, we in North Carolina are presuming that these will get released for public consumption unless our statute operates the opposite way now. And Justice Earls, I don't know if you wanted to add anything.
Well, that's what I was going to, roughly what I was going to say, but I think the whole reason for considering this is the concern that's been raised that it is actually not an easy thing for the public, for the people involved in the incident, it's not an easy thing to figure out how to go to court and get a court order allowing the release. and so the goal was to make the recordings more easily available and flip the presumption both in terms of whether or not it would be released, but also sort of who has the burden of producing the evidence, the information that would we're changing the burden of proof, if you will, and saying that what you need to come forward with is a reason why it should not be released, rather than what you need to come forward with is the reason why it should be released. And that seems to me a pretty significant difference.
And just having operated within that statute before, I will note anecdotally, it's really convoluted, trying to figure out who should consider which factors and who shall release or may release, and then allowing the court to release, and then the factors for consideration. So it is very difficult to work through the statute, even from a lawyer's perspective, when we're trying to figure out burdens and that kind of thing, as currently drafted.
I have a question on, really process, I guess. So would this recommendation mean that whether there's a request or not, that police recordings are released some kind of way from critical incidents, or is this recommendation request driven? Am I making sense?
You are, Chief, and it's the former, so it's not request driven. This is a statement that critical incidents should be released for critical incidents.
Okay. And the other reason I asked that is, and as I've said before, my concern is not about transparency about police. I'm going to give you a scenario. A domestic violence situation where the officer was in a very long fight with a spouse that was about to shoot the wife, and a 4-year-old in the house. A very long 2-minute fight, which is a very long fight for officers. One of the other officers was completely knocked out of unconscious, and the media wanted the video footage of this encounter, and the suspect was killed as a result of this. He had successfully gotten the other officer's gun. Long story short, the victim, the wife, whose life was saved in the 4-year-old, the wife contested not releasing this video. It was very traumatic for her. Actually, it was traumatic for the officers too. So I'm just wondering also, in this, is everything an automatic, or is there some kind of mechanism in place for someone who contests the release of a video because of other reasons than we want to prosecute a police officer? Because we have all of those different kinds of scenarios. So I just wanted to put that out there.
As drafted, Chief, I think that it would be released automatically. I think that if you want to consider that, we should build it in as part of the recommendation, that a person has a right to contest, a victim has a right to contest. They would probably need to go to the court for a showing. Sheriff?
And Chief, in that scenario, was that in a private setting completely? Did that encounter happen completely in a private setting?
Yes, it did.
And so we have to take in consideration that some of this is not in the public or did not occur within the public. And when you have a private setting like that, although you have a government entity involved, still that is a real argument that must be made and considered. The scenario you gave, Chief, which was excellent. I'm just extremely concerned that it's just automatic.
Yeah. In my years, some of these that I watch, I couldn't watch the entire video. And I'm not saying that we shouldn't be transparent, but I think we need to make sure that whatever we write as a recommendation makes sense to everybody who's involved.
So I guess we're at a drafting place, Leslie, because I mean, I think their points are valid, but what I don't want to see happen, and I appreciate the chief really consistently sharing, you know, the need for transparency and her openness to transparency. I just want to make sure that as we're checking off various scenarios, we don't get all the way out to the point where there's now not the level of transparency that we know the public is asking for.
Right.
And I'm not an attorney, so I don't know how that gets wordsmithed.
It seems like there should be some process for a victim to be able to go to a court official to basically say, this could be very traumatic for my 4-year-old to see this on the news over and over again, and have it in that setting and not be a decision that I make as a chief of police. Pretty much the way I think the language was in California. If there's some compelling reason, there is a process that could take place. And I'm not saying that that would be every time, but there's some very sensitive kinds of situations, even in situations where it's a suicide, you know, the family member said, please don't, you know, show my spouse shooting himself on the news, you know.
And so we have C, which requires redaction to adequately protect privacy interests. But then I added B, that is essentially not us trying to wordsmith it here in this group, but makes clear that the will of the group is that any legislation that gets drafted should contemplate the ability to object to release of certain portions that might involve sensitive situations or implicate other privacy concerns. That way we're not wordsmithing it here, but stating your preference for that. How does that look?
I'm good with that.
Yeah, I'm good as well. I think this is necessary statute amending based upon how we want to move forward with making sure critical incidences are fully transparent when appropriate to the community. So I'm good with it.
Okay. Sheriff, anything you wanted to add?
No, I'm good with it.
Okay. So I guess at this point, if no more discussion, I would take a motion.
I'll make that motion that we submit this recommendation.
And a second.
A second.
Okay. Any further discussion? Hearing none. All in favor, say aye or raise your hand.
Aye.
Sheriff Ingram, was that an aye? I'm sorry, I'm having a little bit of trouble.
Aye.
Okay, thank you. All right, so I think that one passes as amended. I will get that sent over. The next question I think that we need to take up is this question here. Should we commission a study regarding the effectiveness of body-worn cameras, which is what some of the literature that you received said some states have done? Or do we feel strongly that body-worn cameras should be mandated for every agency, given especially the number of agencies that are currently using them, and the public's need for transparency? And then if so, if we feel like we should mandate body-worn cameras, then we have a slew of questions I think that we need to tackle and discuss. But I think the first question for the three of you is, do we want to recommend that every agency use body-worn cameras?
I don't have a problem with making that recommendation. And I think we talked about it before. Once we make the recommendation, I think some of the agencies might be more receptive if they knew they were having some support, you know, from a fiscal sense, from the state or whoever, in order to make that happen. But I absolutely believe that body worn cameras are an essential tool in the toolkit of police officers today.
Representative Galliard or Sheriff?
Yeah, I would agree. I think that this is going to have a whole lot of ripple effect once it leaves us, so I think we need to have I think it's the right recommendation. Let me be clear about that. I just don't think there should be any, we should not assume that there's not going to be a whole lot of discussion, a whole lot of, one of the things that we dislike significantly in the General Assembly is unfunded mandates. And so, because we just know there's a lot of pushback on them. And so I think it's the right recommendation. I just think we have to have an openness to understanding. It's going to be a whole lot of negotiation, a whole lot of, back and forth in the legislature to kind of get it over the finish line. But I think from our committee, it's the right recommendation.
Okay. And Sheriff?
I'm in support of wearing body cameras. I have been from the start. It's just we have to be careful who we specify wear body cameras within the agencies, and for obvious reasons. But I am in support of that, especially for our patrol functions. And in the case of sheriff's offices, our detention settings, I think that's very important.
So I believe that that's unanimous to recommend body worn cameras. So I'll draft the recommendation to say, recommend that all that that's a pretty simple one. Recommend that that body worn cameras be mandatory for all law enforcement agencies in North Carolina. I think once we get that one through, then the next set of questions is let's talk about funding. Let's talk about who, let's talk about what's recorded and when. But do we have consensus as to that recommendation?
I concur.
Okay. In that case, if there's no further discussion on that point, do we have a motion for that?
I do want to have some discussion real quick about that. Even though we're making it mandatory, do we also understand that, it's going to require funding, but at the same time, what happens if you have a body camera go down and then an incident occur? I want to make sure that all of this is taken in consideration, and officers or agencies are not penalized because of situations like that occurring, because we've had that. We have a very robust body worn camera program, but we do have those situations occur. And I just think we need to specify that, because I can see so many scenarios when it would cause a lot of concern or issues for the agencies.
And Sheriff, if I may, to that point, I think that how we could address that is if we say, for example, all patrol officers or any law enforcement criminal justice officer who is on routine patrol, because sheriff's offices don't necessarily have patrol officers. So I think we need to make sure we're including everybody, using inclusive language there. All criminal justice officers on routine patrol must wear body worn cameras, et cetera. But we could make an exception that they do it in good faith, that they're using it how they're supposed to, that we understand mistakes will occur, but that they should do it and should operate in good faith. I think adding a good faith exception for the officers there could be a way to consider that point.
Thank you.
So I think we have consensus that we should move forward for mandating body worn cameras. So then the first, I think, question after that, well, first of all, I think everyone has raised funding. Do we want to recommend that adequate funding or funding? What would you like to discuss in terms of funding? How would you like to recommend that funding be available for smaller agencies or agencies who might not be able to afford it?
I don't know that that's in our purview. And it's going to come up as a result of the recommendation. And I think every agency is going to have to uniquely address it, whether it's legislatively, whether it's through grants, whether it's through other resources. And so I personally don't know that it benefits us to address it here because we have no authority to do anything about it one way or another.
Okay.
Um,
So, go ahead, Chief.
I just had a quick question. Representative Galliard, when these types of recommendations are presented to our legislation or our legislators, do they get shot down sometimes mainly because no one wants to look for, the funds, or the state feels like they can't fund it or support it, and then as a result, it just gets shot down?
Yeah, it definitely happens. I mean, there's only so much money to spend, and the biggest bill we pass every year is the budget bill, and so, and it's the one we spend the most time, fighting about, and so rightfully so, because I mean, again, there's only so much money, and it's going to be complicated in this next legislative session because we'll probably have decreased revenue receipts because of COVID. So lots of people are going to really be struggling about it. So yes, it is. I wouldn't say it's likely. I'm just saying that I've seen great statutes removed from bills just because we couldn't figure out the financial part.
Right. That thought came to me because, similar recommendations that we've made, I'm constantly thinking in terms of how they impact budgets. And when they go before, the state, will they get shot down, even though they're great, even with our accreditation recommendations? Will the funding be there to support accreditations for all law enforcement agencies? So I hate to see all of the great work that we're doing here. I'm not saying that that's going to happen, but those are the things that I guess we need to consider as well.
Yeah, and it's a good point, Chief. And I think that's where the work of lobbyists, the work of the general public, and the work of those of us, we have to work on both sides not to politicize this. And we have to ask ourselves the question, do we think it's the best thing for our state that law enforcement officers wear body worn cameras? And we're going to have to go on record with a position one way or another. And then if we agree with it, we'll find the money. And so, I think it's worthy for the recommendation. I think it's going to be a worthy discussion in the General Assembly. And, I'm hoping that we'll get it across the finish line fiscally.
Yeah. Thank you.
And so given that we don't feel like we can make a budgetary request within our recommendation, my next question is maybe implementation date. I do think that might be something to discuss. This is not something that our law enforcement agencies will be able to stand up overnight, especially those who aren't currently doing it. So do we have thoughts about, we want them to be substantially employed by or deployed by 2022, or is there, what do you think? I think Chief, you and Sheriff Ingram probably have better idea of what's realistic in terms of standing up a body worn program within an agency, and how long that might take to get up and running.
I think we'd have to consider the window of it being, mandated, and when that would happen. I'm sure that would happen, I guess, during the upcoming General Assembly, perhaps. And then once that happens, it takes at least 12 months to stand up a body camera program, because cities have to go through the RFP process, and then they go through the training process or the pilot process. So you're talking about 2022 at least. And I would say an ambitious time frame would be, say, at the beginning of the budget cycle, July 2022. Most folks operate on a fiscal budget. Sheriff Ingram, you got any thoughts about how that would potentially roll out in time frame? he may be dealing with some other things. A lot going on today.
There is that. So I could say legislation mandating body worn cameras must require, should require, I guess we can't must, the legislature.
Leslie, I'm sorry, I had to take a call.
It's quite all right, Sheriff. We were talking about how long it takes to stand up a body worn program and whether we should put a time frame on it. The chief was talking about how the RFPs, it might take a while for a city to get that stood up. And so I've made a suggestion here saying that the legislation that it gets drafted mandating the body worn cameras should require compliance within 2 years of enactment. So that gives a window of time for agencies to do the RFPs, find the funding, get the policies in place, that kind of thing.
I understand, and I agree. It definitely will take some time.
Okay. And 2 years seems reasonable to both you and to Chief Davis.
It does to me.
It does, yes.
And I'm gonna need about 15 minutes away, and I'll be back. Okay.
Yes, sir.
Thank you.
Thank you. So I think Chief Davis and Representative Galliard, if y'all are willing to go forward, we can keep talking and maybe we'll get some points nailed down and can bring Sheriff Ingram back up to speed before we vote on them, if that works for the two of you.
Yep.
Okay. So then the next question, I think after first they should be mandatory, agencies should comply within X amount of time. I think the next question is who should wear them? And I think that, just saying wearing body worn cameras is one thing that people think about, but are we talking about detectives? Are we talking about command staff? Are we talking about undercover? And how do you think that should be spelled out?
Yeah, I think you have to really look at the actual role of the sworn officer as opposed to their classification at the time, because some of my investigators wear body cameras and some don't. Just because they're investigator doesn't really dictate them wearing body cameras. I have gang investigators that are out in the field. I think the language should, sort of define the role of the officer, and primarily those individuals that have an interface with the community, that are operational, that are, patrol. And it may require us, using some specific words, but the legislation might be able to do that, as well, Leslie. And I wouldn't just assume that sheriffs aren't on patrol. A lot of them are on patrol.
Right. I just don't think they call them patrol officers.
Exactly.
So we wouldn't want to say patrol officers. So I think saying criminal justice officers on patrol.
Or that work in a field capacity, those individuals that are actually conducting traffic and those kinds of activities.
So definitely must be worn by those on patrol or who work in a field capacity. But what about should be worn by detectives in X kind of scenarios? And
right.
An example that comes to my mind, I had a long conversation with my husband about this. He's an officer and he is a detective, but wears his body worn when he goes to do interviews, even follow-up interviews, wears his body worn. That's part of their policy that he has to wear it during the follow-up interviews, unless it's a particularly sensitive victim, like a rape victim or something like that. So do we want to build in certain parameters there? For example, you wouldn't necessarily put a body worn on an undercover when it might compromise their safety in a scenario. So what types of parameters?
Yeah, I would say in the capacity of confidential kinds of activities, sensitive types of interviews, say for instance, you're your crimes against children interviews. You don't wear a body camera when you're interviewing a child, you know, so there are going to be some, and I guess you can kind of massage that how you feel like you need to, but those situations that require a certain level of confidentiality or investigations that are of a sensitive nature. And then, of course, we can give examples at some point, you know, undercover, domestic violence sometimes, or sex crimes, you know, sexual assault victims. We don't wear body cameras with those either.
Leslie, is there any existing legislation or statutes from other states that we're looking at relative to these questions?
On that, I'm going to defer to Jean-Paul. I think that I hope that he is still on.
Yeah, there is some that we could refer to as well. There's some best practices out of DOJ that really outlines, and I use them to develop my general orders as well. The Department of Justice has some good ones. The Police Executive Research Forum has sample general orders that actually have some of this language in it as well. And even some things that you may not have thought of, you know, in their research, but Jean-Paul might have some additional information.
Yeah, I, definitely echoing what Chief Davis said. And then there are a number of state policies that Leslie included in your materials, as well as are referenced in the memo. Colorado recently passed a very comprehensive statute that has carve-outs and all that stuff. I think California and Minnesota also have sort of a good listing of these sort of like sensitive carve-outs that might be good to look at. So there are a number of places to look.
Jean-Paul, have you looked at the, or have you had your hands on the body-worn camera toolkit that was put out? It's several pages long. It was put out maybe 5 or 6 years ago, but it had some sample language and policy recommendations for agencies.
Yes, I did take a look at that. It's been a few weeks now since I have, and I think it's expanded a lot since then. It actually has
Okay.
Like a few North Carolina policies in there. So that's definitely something that we're aware of, and to the extent that
Great.
So if we drafted it then to say body-worn cameras should be worn by criminal justice officers when conducting investigations unless the investigation is of a sensitive nature, and then to further define what that set of interactions is, the drafters should consult similar statutes in other states, and I've given the examples that Jean-Paul gave us, as well as best practices from where, Chief? IACP or somewhere else?
IACP, Police Executive Research Forum, which is, PERF. And the last one would be NIJ, I believe it is, the National Institute of Justice. They have a lot of body-worn camera studies out there as well.
Okay. And again, I think that sets the working group's expectation that, we think it doesn't just apply to patrol, but it also does not require us to get into on such a short time frame what the minutia is of every exact scenario.
And just so you'll know, there has been sort of a tug of war between police chiefs and the Department of Justice as it relates to task force officers wearing body cameras. And many chiefs have had issues with their officers working task force. And Leslie, I see you nodding your head. And we have sort of, been having conversations with the feds that if our officers cannot comply with our department's policies, we're going to pull them from the task forces. So I think it was either Friday or Thursday they finally acquiesced to our, recommendations and said that law enforcement agencies who have officers on task forces are now allowed to wear body cameras. So that was a win. And I think it sort of sets the stage really for what we're doing too, so that there isn't a lot of resistance. Now the feds are agreeing that our officers should be wearing body cameras.
I think that's great, Chief. I had heard the problem. I had not heard the solution. So that's wonderful.
Oh yeah, I did a happy dance over here when I saw that. Good.
So I think, looking at our questions here, who should wear them? Is there a feeling that we should explicitly exclude command staff, or is that kind of implied?
You might need to say it, because I'm in the, I go out in the field from time to time, for community meetings and whatnot, but I'm not the person that's actually in the middle of a crime scene, and neither is my command staff. So, but I guess we need to be careful there, because a smaller agency might consider a sergeant or a lieutenant part of their command staff.
That's true.
I think if we stick to those individuals, and you described it earlier, that work in a field capacity or a patrol capacity, they should be wearing body-worn cameras.
And I think specifying, we might not even need this, specifying when conducting an investigation or patrol
Yes.
or field. So if you did, or if you were in a smaller agency, if you were the chief of a small agency and perhaps you did participate in that, then you would wear.
Absolutely.
But if you didn't, then you wouldn't. I think that covers that.
Absolutely. I know some chiefs that still pull cars over, and I scratch my head when I hear about that sometimes.
So then I think that we've covered the, who and when. Are there other scenarios when they should be worn other than patrol, field capacity, or investigations?
To tell you the truth, without looking at my general order, that just about covers it. But I know we'll have an opportunity to wordsmith this more as we look at general orders when they're doing the final, legislation. But I think that sort of covers it.
And then the next question down here, my stuff has gotten a little renumbered, but what exceptions should be specifically noted for when they should not be worn? I think that we've noted that sensitive scenarios, we're going to look into that. So I think that we've addressed that one.
Mm-hmm.
And then what about accountability structures to ensure that they're being used properly? So I think this gets to Sheriff Ingram's question earlier as well about an officer who's doing everything they think they should be, but their camera fails, and that's not their fault. So first of all, what accountability structure do we want to recommend or suggest for someone who refuses to follow this mandate?
So I think, what you have to put in there is that random audits should take place, and that's in our policy. Supervisors have to conduct X amount of random audits, and you might not have to, specifically say how many, because there's some recommendations out there. Random audits of not just the officers' practice and use of the camera, but also audits of the mechanical functionality to ensure that cameras are operating properly.
Chief, do those audits include how the data is properly being archived?
Yes, absolutely. And the time that is being archived, because cameras should be uploaded within X amount of time of a person's shift. It can't be 24 hours later, the officer decided to upload his camera information.
Got it.
So Chief, I missed the first part that you were saying. I was typing ensure compliance with the mandate, but the mechanical functionality of the equipment, and you had said right before that
Yes.
to not only ensure that they were
that the officer activates his camera at the appropriate times. That information, that data is also audited as well. So what we do is there's a cross-reference. Certain types of calls, you have to turn your camera on. So we query officers' activity sheets to see, okay, on 4 traffic stops on this particular day, pull that camera footage for those 4 traffic stops to make sure that the officer turned the camera on. And they also look at that camera footage to ensure that the officer conducted him or herself, in a manner that's congruent with the department's policies and procedures. And sometimes we discover you were discourteous to this person on this day. The person may not have even made a complaint, but that's our way of, holding our officers accountable and checking ourselves,
Chief, given how large your agency is, it seems like this could easily be a full-time position, just kind of running these audits.
So you accidentally muted yourself, Representative Gallier.
Yeah.
But I heard you.
Okay.
And you're absolutely right. Body camera programs automatically you have to build in, sort of your coordinator, the person who oversees the actual ordering and replacing of cameras and turning in cameras. And then you have to have individuals who oversee the auditing process. And all of the supervisors are now responsible for that auditing process, and that is built into their evaluations as well. And I think that might be very helpful for folks to know as we roll out this recommendation, that it has to be managed and audited, or it's no point in them wearing body-worn cameras.
Yep. What gets checked gets done.
Yes.
okay. So I think we've covered that one. And then should public input be obtained?
I'm not sure what's being asked by that, Leslie, but I mean, all of the data I see suggests that there is a broad support in the public. Yeah. Officers wearing body-worn cameras. So I don't know if that question is asking something beyond that, but I think we already know the data on the public wanting it.
So that question was relevant at the onset of the whole body-worn camera exploration some years ago. When we did focus groups with the community, now that body-worn cameras are a part of everyday use for many agencies across the country, I don't know how relevant it is. And to your point, Representative Gallier, I don't know a community that, today would say they don't want body-worn cameras.
And I think that's what that question was there to address. So I think that the next question then is, should there be penalties for failure to comply? And to me, this is a 2-part question for you. One, should there be penalties for agencies who fail to comply with the legislative mandate? And 2, should there be penalties for individual officers who fail to comply? And I think perhaps this is where we draw the distinction that Sheriff Ingram mentioned, that officers who are trying to comply, but for things outside their control, their equipment fails, we need to make sure there's a good faith exception for that.
Right. And there's language built in general orders that address that an officer will not be penalized for mechanical failure of his body-worn camera if we determine that was the case. However, it's also in the general order that officers will be penalized and disciplined for failure to activate their body-worn cameras. And we do that on a regular basis. And that process is sort of a progressive disciplinary process. Initially, we gave officers sort of a 6-month period to get accustomed to new technology, to the use of the camera. And once we got past that, right now we don't give passes for officers who don't activate their body cameras when they're supposed to.
It makes a lot of sense. So Chief, I've got this here. Let me know if you think this captures it. Officers should not be penalized for mechanical failure of body-worn cameras outside their control. However, officers may be penalized for failure to activate their body-worn cameras in accordance with their general orders.
Absolutely.
Okay.
Chief,
Sorry, go ahead.
I'm sorry, Leslie. Chief, in your department, are body-worn cameras, are they department issued per officer? So this then becomes my camera, like my weapon would be?
Absolutely. It has a unique number that's assigned to that officer, and is recognized when that data is mounted for uploading. It automatically sends that data to Officer Jones' file, so to speak. So there's no intermingling of cameras between officers.
Got it.
So then my next question for you is, what about agencies? So say we have an agency in North Carolina who the legislature passes this bill saying body-worn cameras are mandatory in North Carolina. We have an agency who refuses to comply. It's hard for me to see that happening, but is there a scenario that we need to address there if that were to happen?
The only reason I can see an agency not complying is if at the time it's cost prohibitive for them, and we haven't provided them with, the resources, the financial resources that they need in order to make that happen. And what would that penalty be for the agency? I don't know what that would look like.
It's similar to the failure to comply with the collection of data, some of the data that's required. Right now, the data, at least the ones we were talking about with the traffic stop data, if you don't comply with that, you potentially lose some of your ability to get grant funding. But there's not a lot of teeth to that. It's just that's kind of the loss there. And I can see if I can pull up that exact language.
Yeah, I can see where you could potentially tie this to, if we have mandatory accreditation, one of the best practices that exists in accreditation is that agencies have body-worn camera programs and that they comply with body-worn camera programs. So an agency could potentially lose their accreditation if they don't comply with this best practice. I mean, that could also be a part of it.
So let me muddy the water just a little bit, not that it needs to be, but because I represent a rural community, and sometimes the resources are more limited in rural communities than in other communities. What, Leslie, if we had a scenario by which an agency said, listen, the only way we can afford to do this is for us to put an increase in taxes on the next ballot referendum because the community is going to have to pay for it. We just don't have the money. The election comes out and the community doesn't pay for it. They say, you know what, we're not passing this 2-cent increase or whatever the case is. What then happens to that agency who's not able to comply because of that issue? Maybe that's too much of an outlier of an issue, but I could really see certain agencies and certain communities saying the only way we can fund this is if the people allow us to raise taxes.
Right, and not just the cost of the cameras, but the cost of the manpower that's going to be required to manage the program. So whether the agency is a small or large agency, you need at least one administrator. You need somebody who's sort of the overseer, and that position would need to be, part of the budget request too.
So right now in the traffic stop statute, the penalty language reads, an agency that does not submit the information as required by this subsection shall be ineligible to receive any law enforcement grants availability by or through the state until the information is submitted. So that's the stick, if you will. Yeah,
and really that That doesn't have any teeth in it, really.
That's right. That's right. It really does.
That's Snaggletooth right there.
Yeah, I wouldn't call that one a stick.
Yeah.
That's big at best.
Yeah. Yeah.
Yeah. And some agencies might say, I'm not getting anything from the state anyway.
So
Looks like the Attorney General just came on, so you may, oh.
Yeah, I'm back. Oh, sorry for being a little bit late. No, nothing to add. I mean, the other thing is, I don't feel like we always have to answer every single question. I mean, we can make a proclamation that every agency should have body worn cameras, and that it's mandatory and it should be part of its certification. But, you know, the legislature can also answer the question, what's the consequence if they don't, if they agree with this policy determination? So I don't feel like we have to answer every single question and every permutation.
I don't know about y'all, but I think that he might have just let us off the hook on this question.
That's what it sounds like to me.
So, which, you know, I think is a tricky question for us to answer anyway. And then the only other questions that I had for discussion were, what about other types of recordings like dash cameras? You know, if we're going to mandate body worns, do we also mandate dash cameras? I've tried a lot of cases where that's the critical evidence. And it certainly, to me, is great when the patrol vehicles or vehicles equipped with lights and sirens have those dash cameras also.
I think if you do it from an implementation standpoint, it makes sense for an agency to roll those camera systems out at the same time so they can be compatible with each other. Because a lot of agencies had dash cams long before they had body cams. And the issue was that you had two systems that weren't compatible. But now technology has gotten to a place where whoever is providing your body camera program can also institute the dash cam that are actually compatible with the body cameras. And they have activation kind of features that are, sort of correlate with each other. I personally believe that dash cams are very important because when that body camera failure occurs, whether it's a mechanical failure or whether it's the officer's failure, that dash cam has been the backup to be able to capture some very critical moments on a scene.
So I drafted it as a separate recommendation, given that all of the stuff we've talked about with body worns doesn't necessarily apply. Some of it might, but that we would recommend that all agencies deploy dashboard cameras in all vehicles utilized for patrol or in a field capacity. I had started to say marked vehicles, but I realized that probably doesn't cut the mustard for a lot of different reasons. So what do you think about that, Chief?
That's a good starting point. Most of my undercover vehicles do not have dash cams. Sort of takes away from the undercover element anyway. But I would say definitely the marked vehicles, because those are the vehicles that are out there that are involved in the kind of activity that we're talking about in the first place.
And so I guess what I'm thinking about is not an undercover vehicle, but an unmarked. So an unmarked theoretically could be used for traffic enforcement or some sort of, so
maybe some of that same, that terminology in a field capacity, okay. It does cover unmarked vehicles as well. If you're doing a traffic stop in an unmarked vehicle, and actually I can't remember, is the state of North Carolina, some states prohibit that, traffic stops in unmarked vehicles. I couldn't remember whether or not, we don't do traffic stops in unmarked vehicles.
I think you can still do them as long as there are lights and I think that there are unmarked vehicles that have lights and you can still pull, like a detective's car that has lights. I'm 99% sure that it is allowable as long as there is some sort of police element to it, like the lights or the sirens, even if it's not marked on the side.
Okay. And I think in a field capacity or traffic enforcement capacity, sort of captures that. I can't imagine an unmarked vehicle having a dash cam if it's not being used out in the field in some way.
And so then with dash cams, theoretically, the random audits could apply to that as well. And also the penalties for failure to properly utilize could be used for that as well. I mean, I think that those are things that translate. What do you think?
Actually, for the dash cam, it's not as much the officer's responsibility to activate the dash cam.
Okay.
It's the department's and the fleet manager's responsibility to ensure that all those dash cams are working. And even officers don't even know how to, check or make sure it's working. It's when they turn that engine on, that camera comes on along with all of the other bells and whistles that are on that vehicle. So they're not exactly responsible, or you can say something that the agency will be responsible for ensuring that vehicles equipped with dash cams operate, appropriately.
Okay. Now I'll check and see. Sheriff Ingram, are you back on by any chance? All right, I think he is still here. Anything else that you can think of that we need to cover with respect to body worn camera recommendation or dash cam recommendation?
Not at the moment, Leslie. If something else comes to mind, I can let you know. I can send you an email.
Okay. And Attorney General Stein or Justice Earls, either of you have any further thoughts or input about those two recommendations?
I don't. Thanks.
Oh, thanks.
Okay, I guess what we'll do is come back. We can't vote on these because we don't have a quorum, but when we get Sheriff Ingram back on, then we can come back and maybe vote on those while we discuss the other, if that works for everyone. So the next set of recommendations is things that we would recommend to standards commissions regarding entry, decertification, and data collection. And I think the first recommended solution is pretty much a no-brainer to recommend support for the RAP Act program that's been voted approved by both commissions already. And so now it's going to require legislation and amendments to the code. So both commissions have already voted to support it. I think this is what would be fingerprinting officers to make sure that if they are convicted out of state, that we are notified in state that it might affect their certification. So hopefully that one's a no-brainer. The second draft recommendation is to recommend that the Standards Commissions revise the two provisions of the code. The first one is for CJ and the second one is for sheriffs, to require that criminal justice officers not engage in excessive or unjustified use of force. And those are just words that I have put in there as a placeholder. Certainly, I wanted to capture the concept for our discussion, so those words are subject to change. But the idea being that in the requirements, and I think the chief is probably real familiar with these as well, given that we have done a lot with these provisions at CJ. But for example, this is the sheriff's provision. And I think, have y'all got 12 NCAC 10B0301 on your screens? Okay.
Yes.
Yep.
I just want to make sure I'm sharing the right thing. So these are the requirements, the minimum standards for justice officers. And you can see that they require lots of things like being a citizen of a certain age, high school graduate, fingerprints, etc., drug screen, notifications of criminal offenses, notifications that when a case was disposed, domestic violence protective order violations, that kind of thing. And then we have things like, so that's notifications, I guess, of any criminal conduct. But then we have things like be of good moral character and have a background investigation and haven't been convicted of a crime. But be of good moral character is the one that we often see at the commissions. That's kind of the catch-all. And what is good moral character? And we have a slew of case law that says sort of what it is, but the cases, it's a case-by-case basis decision, and the agencies are defining that in final agency decision. Within good moral character, there are certainly times when an officer's use of force has caused them to become or caused their certification to be in jeopardy in front of the commissions, and caused us to consider that as part of the probable cause process. But it's not specifically listed either here or in the requirements for CJ, which are almost the same. Their good moral character is a little bit different. The good moral character language is a little bit different. They call it moral turpitude. Engage in any conduct that brings into question the truthfulness or credibility of the officer, or involves moral turpitude. So again, same cases that are listed in the sheriff's statute. The question then becomes for this working group is, in looking at the recommendations, let's see here. I think I've got the right, nope, that's our civilian review boards. Okay. Okay, let me try this again. Go. So then the question becomes, do we want to add requirements, specific requirements for officers who engage in excessive or unjustified force? What that would do from a practical standpoint is allow someone, allow the probable cause process to be initiated at the commissions when someone has excessive or unjustified force. And right now that could happen, but it would have to be couched as either moral turpitude or good moral character. And so if we wanted to be that explicit, if we wanted to recommend to the commissions that they require that as an explicit entry requirement, first of all, but then also allow it in question number 3 to be a basis for the probable cause process to be initiated against an officer to take their certification, or to conduct some kind of suspension or revocation. Chief, I think you're on mute. Yeah.
Yeah. So with this one, Leslie, this means that there will be a requirement for the agency to report to the commission when these incidents occur, as opposed to the officer having to go before the commission because we took their certification away or we fired the officer.
So I think there are 2 parts to that, Chief. I think that the short answer is yes, but I think that in the minimum standards, so if we're looking at 09B 101, here are the minimum standards. These are things that the officer they have to be these things. They have to report these things when they initially begin the process. So that, I think, would be a self-report. If they've come from an agency, say they're switching commissions, they're leaving a police agency and going to a sheriff's agency. If they have to report a use of force, that's on them for the minimum standards. But then if we look at the suspension, revocation, or denial, that's probably going to be an agency report, because that's not dependent upon an initial certification process. That's the agency is going to have to report that to the commission to have that process started.
I actually think that if the agency is submitting an incident of use of force to the commission, I think that obviously that incident was serious enough for the commission to consider decertifying an officer. That doesn't happen today. And I think that would help cut down on some of the roving officers that we talk about that go from one agency to the next. So, of course, that requires a different kind of work and process for the commission, because it'll be more cases, wouldn't it?
I think it would,
Yeah.
because it depends on how we're defining these use of force or excessive, or how we want to look at that concept. And it could be that, and as you know, Chief, this is going to have to go to the commissions for rulemaking
Yep.
on all 4 of these rules. And it could be that this working group makes a recommendation that, and it could be as simple as making a recommendation to the commissions that they add excessive force or abuse of power or something like that to the reasons for suspension, revocation, or denial, and for the minimum standards for entry. So we could do something that simple, that we would not have to wordsmith, because the reality is the commissions are going to wordsmith it
Exactly.
when it gets there.
Yeah, I think that's good, because the commission can also decide whether it goes to the probable cause committee before it comes to full commission anyway, right?
So, right, it's always going to go to PC first,
Okay.
because the standards division staff investigates first. If then it goes to what's called pre-PC, and if the staff believes there's PC, they send it to probable cause committee, and then they hear it, and what comes out of that goes to OAH, and then to us for final agency at the back end of that. So it goes through that whole process. So this would basically be on the front end. You have to not have had excessive or unjustified use of force in your career as an officer to even be certified in North Carolina. So that's on the front end. And then the
Right.
second question here in number 3 would be, and if you do, while you are certified, the commission can suspend, revoke, or deny your certification on that basis.
And so this one also will depend heavily on the integrity of the agency. Not saying that we don't have agencies that don't have integrity to do the reporting in the first place.
So that's number 4. If you look at it, the question is, we could request that the commissions revise the notifications by the officers and the agencies to standards, put that specifically in the code that agencies have to report it, which could account for some of that.
And I guess defining and ensure we define well what excessive use of force is.
Right.
Because what I consider excessive use of force in my department may not be considered excessive in somebody else's department,
And so those are exactly the questions I think. I've drafted this as a basic recommendation for you to consider.
Okay.
Do you then want to either define excessive or unjustified further, or choose different words? Also, if you're wanting to consider abuse of power, if so, how is that defined? They're all, as you say, Chief, kind of nebulous terms. So how do we make sure that we get what we're looking for?
Yeah. To tell you the truth, I really think that you might be talking about 2 things here, abuse of power and excessive force. Abuse of power could be, targeting a certain community and writing tickets to over and over again to certain people, and of course, excessive force is also just as serious as abuse of power. I think you might want to keep both in there, because that abuse of power could really capture some other areas, especially if it's an abuse of power that's really egregious. It might need to go to a probable cause committee. This might be somebody that we don't want, in the law enforcement industry. But of course, I know the standards committee will have to do most of the work on this, because this is one that you're definitely going to have some clear definition of who falls in these categories, which is good. I think it's good, to tell you the truth, because on a national stage, that's what we're really trying to advocate, is that officers that have these egregious histories don't go from agency to agency, even, going from one state to the next.
That's right. And I think that that's, hopefully we can do in the commissions is to try to prevent that and the wandering officer issue. So then the next question, so I think I've added as to section 2, required criminal justice officers not engage in excessive or unjustified use of force or abuse the power of the position. We could define that further, or we could send it to the commissions as a recommendation. I mean, since we can't change the code, I think they're going to have to ultimately define it.
Yeah.
Representative Galliard, what do you think?
Well, this led me to a different question. And so if I could just raise it real quick, because this is, if I'm understanding the conversation and following it, this is being directed about the officer, but what about the agency? And so is there, because we're talking about abuse of power of an officer, but the officer could have one incident, right? 2 incidences, but it could be every officer in an agency. And then the real issue then becomes the culture of the agency. At what point is there a reporting of the overall agency as it relates to abuse of power, or does that not really occur?
I don't think it really occurs. I think that the administrative code isn't built to collect the information about agencies. That said, if we look down at number 4, if we're further recommending that this standards division maintain the information as part of a publicly available database consistent with personnel laws, or that they require hiring agencies contact standards divisions, the requiring that it be maintained at least provides the accountability from the standpoint of someone could look and see if, a certain agency had these problems with every single one of its officers, that kind of thing. So that it could provide some of that transparency, although I don't think the code right now as drafted specifically deals with agencies who fail to change their culture.
And, I think that the, excuse me, the accreditation process could also capture some of this, because when you are up for reaccreditation, they look at your agency's history or culture of disciplinary issues centered around use of force, what the community's perspective is or perception is about your agency as a whole. There's some checks and balances there. That's if the accreditation mandate, goes into effect. You could potentially use that as an opportunity to say, unfortunately, your agency is not going to be reaccredited because you have allowed officers to create a culture of inequity or mistreating the community. And if that happens, then what are the ramifications for an agency that does not get reaccredited? As we talk about the mandate for accreditation, what if I fail my accreditation? It's no longer that I have this certificate hanging on the wall. What is the state basically saying that the ramifications of that is? And I know I kind of went off into another area, but I think it's all kind of interconnected.
And I think that's probably why maybe, Chief, the code doesn't address it, because the accreditation process does for agencies.
Yeah.
And Sheriff Ingram, are you back with us? His icon's still there, so I feel like he may still be coming back, even though we're drawn towards our time for close. In recommending this, in the second recommendation here, to allow for suspension, revocation, or denial of certification based upon a criminal justice officer's history of excessive use of force or abuse of power, I think this is one we deal with fairly often in the sense of at the commissions, when we get a case based on good moral character or moral turpitude. Is it a history of actions, or is it one particular action that rises to the level? And so how do you feel about, should it be the history of abuse of force, excessive force, or abuse of power, or should it be the case that one incident can qualify in a certain scenario? What do you all think about that?
I absolutely believe that one incident could qualify in a scenario where if an officer did something so egregious that this wasn't a mistake, this wasn't a performance issue or anything like this. This officer intentionally did A, B, C, or D, and he could have had a good history, but based on this incident, he gets terminated. I terminate him based on that one incident. So I don't think it necessarily has to be a history of, incidents.
Okay. So I removed that. Representative Galliard, any thoughts about that or anything else for that matter?
Well, I would agree with Chief's perspective on that. I've always defaulted that one time begins a trend. And so I would agree with that statement. And I think the sheriff is back with us.
I apologize. And I was listening to what Chief was saying, and I definitely agree with that.
Glad you're back with us, Sheriff. I'm sorry that that I did not recognize when you hopped back on. To take you back up through the recommendation, I think we had all gone through recommendation 1 for body worn cameras, and that one had passed. Recommendation 2, that they be mandatory, passed, and the things that we tried to cover in the specifics. And I think the Attorney General rightfully noted that we don't have to have every single specific in here. That certainly that is something that we can flesh out later. The most important point is that we feel like they should be mandatory. But the compliance within 2 years, I think you were on for that part of the discussion. We settled on must be worn by officers who are on patrol or who work in a field capacity to try to distinguish from other types of officers. And then must be worn by patrol or field capacity, but should be worn by criminal justice officers when conducting investigations, unless it's of a sensitive nature. And then, of course, we deferred on what exactly that is, thinking about things like domestic violence, victims of sexual assault, undercover officers who are dealing with confidential informants, things like that we could look at the best practices in other statutes, and then in the IACP and PERF and NIJ directives for that could further, that could be further explored further. Then also that random audits should be conducted by supervisors within the law enforcement agency to ensure the compliance with the mandate to wear the camera, that the camera is activated at the appropriate time per the agency policy, and that the mechanical functionality of the equipment and ensure the mechanical functionality of the equipment and archiving information. In terms of accountability for body worns, that's where we came. Accountability for the individuals using the body worn cameras. And then officers shouldn't be penalized for mechanical failure of body worn cameras outside their control. However, officers may be penalized for failure to activate body worn in accordance with their general orders. So how do you feel about those things? Or any thoughts or comments?
Definitely comfortable with that. The only thing that caught my eye, because I was reading through those, is is following that recommended all agencies deploy dashboard cameras in all vehicles. While we have those and I support those, we are talking about a lot of data storage, number one, and a significant amount of cost associated with those as well. So I just, the body worn cameras really go a long way, and in many aspects are much more versatile than the in-car, the dashboard cameras. So that's just my thoughts on that.
And I think the language there is a little softer than, we recommend that body worn cameras be mandatory, but then in the language for dash cameras, we recommend that agencies deploy dash cameras. So I feel like it's a little softer language than with the body worns, as drafted anyway.
Okay. But it looks good to me.
Yeah. And while you were gone, Sheriff, I explained also that dash cams are not necessarily the responsibility of the officer to activate or inactivate. That's just the responsibility of the department to make sure that it's functioning properly when that officer gets in the car. And the other thing, I think when they start thinking about, the cost implications, the cost isn't the body camera. The cost is storage. The cost comes in thousands and thousands of dollars of cloud storage, or whether or not it's storage on hard drives or whatever the case might be. That's where the money comes in.
Agreed.
So I think at this point, we're about out of time, or maybe we're a little over, but we've passed recommendation number 1 and we've passed 2. But if we want to pass 2 with the additions and then 3, I think that we could probably get those moved forward today. And then next time we can focus solely on the commissions. If there isn't any more discussion about 2 or 3, I think we are probably ready for a motion as to those 2 recommendations.
I move that we submit the 2 recommendations discussed to the larger group.
Do I have a second?
I'll second it.
All those in favor?
Aye.
Great. So I think that we'll move those forward. And then next time, Sheriff Ingram, I don't know when you came back on, but we had talked through some of these. I will resend this document here. But essentially what we're talking about is supporting RATBAC, which I know you're familiar with, and then recommending to both commissions that they amend the minimum standards and also the DCERT provisions of the code to account for unjustified or excessive use of force and also abuse of power. So that's what we were discussing, and then how to further capture that data within the standards divisions in reporting that to kind of prevent the wandering officer issue. So I will clean this up and send this back out to everyone, but that's what we'll focus on next Thursday. And so we have this recommendation to talk about as it relates to the commissions. And then the other thing that's still left that is kind of for cleanup is this psychological evaluation piece. And so maybe the next week, before we meet next week, give some thought about whether you want to go there, whether we want to do that recommendation. This language here is already before CJ. It'll be in the November Planning and Standards meeting, and it will be discussed as the recommendation. So it's the CJ Commission is already discussing it. So query whether we want to also discuss it as part of the working group. So those are the things that I will clean up and send back out to the larger group for next Thursday, which may be our last meeting. We have a full task force on the 13th. We have our next Thursday, the 12th, we have our working group. And then we have the full task force on the 13th. We also have full task force tomorrow. And then after that, and Ellen or Jasmine, correct me if I'm wrong, there may be another full task force meeting on the 18th. So if we need to squeeze in a working group meeting before then, we probably could do so.
There will be on the 18th.
Okay. All right. With that, thanks everyone so much. I appreciate your patience with my internet issues today.
Thanks, everyone. Have